right, good afternoon. This is the House Judiciary Non-Civil Committee. We're here to consider two bills. Shockingly, we'll go ahead and consider House Bill 1015 first. And let me ask everyone, if you would, just these things are great, but put them in a silent, vibrate, or even better, off position. One of those would be much appreciated. I think what I'm going to do is, and let me thank the team from DeKalb again for the presentation that they gave. It was about a week ago here, a PowerPoint presentation on gang activity statewide. I think that was a really well done, tight, very educational presentation. I think it was a real eye opener for the folks who were able to be here. So let me thank them again for doing that. I think the most expeditious route we could take today, and we went over some part of the bill, and we had some back and forth on that last time after the PowerPoint, which again I appreciate. I think maybe the best route to take from a time management standpoint would be for me to go ahead and just go over the bill section by section as I understand it. It is not lengthy and frankly not very complex, which is good. And then I think what we'll do is go ahead and get into any questions that members may have on specific sections. I'll go ahead and invite the DeKalb team again, Ms. Keys-Fleming, Mr. Carlson, Mr. Floyd, Ms. Perkins, if they like to come forward. Because when we get into that dialogue and any questions from the members, I'll answer whatever I can answer. If I cannot, I won't hesitate to go ahead and punt it to the DeKalb team. And then, and I know our friends from the Defense Lawyers Association would want to be heard on a couple of things, and that's fine. We did hear from Ms. Michaels this last hearing about two specific areas. One had to do with the probation supervision provision, which is at the very end of the bill, and then also her concern on Section 5 of the bill, on page 5, having to do with the word associate. I think we answered that at that time, but in the interest of dialogue, we'll go ahead and if there's anything new that she'd want to bring up, or any other member of the criminal defense bar on behalf of any representative on behalf of the criminal defense bar, that would be fine as well. So at their leisure, I'll go ahead and ask the DeKalb team to come forward. I'll go ahead and just start at the beginning. Section 1 of the bill, again, this goes to, and this was enunciated in the Rodriguez case, where Justice Carley made mention of the fact that some of the best, or not the exact wording, but some of the best evidence or best guidance on legislative intent is to go to the language of the statute itself, and some of the legislative intent language, of course, enunciated in Section 1. We add to that on lines 41 through 44 regarding the presentation of evidence of criminal gang activity. Their history, nature, activities, practices shall be admissible in trials and proceedings under this chapter. One note that I had, and I will bring it up now, and I think Mr. Carlson addressed it then, was that this that particular section does not prevent any adversarial proceeding between the defense and the prosecution in terms of admissibility of particular subject matter, correct?
That's correct, Mr. Chairman. There are two evidentiary code provisions in the Gang Act. They serve very specific purposes, and this section added here to 1615.2 at lines 41 to 44 would just provide a purpose behind those specific statutes. So anything that would not fall within the specific purposes of those statutes as already set forth in the law, and they're already there.
And it's not carte blanche for everything getting in.
It would be outside, and in fact the purposes would be to prove something you don't have to prove in any other cases, that this group is a criminal street gang, and also what evidence would go to prove that. So okay. It doesn't open any doors beyond a very specific purpose, only for cases brought under these statutes.
And I know I said we'd go to questions after, but this is something that actually I had a concern about that I did enunciate in the last meeting. I wanted to go ahead and bring it up again here today to make sure that it was clear that this wasn't some catch-all, even though it was in legislative intent language, it was some catch-all provision that everything gets in no matter what. That's not the case.
It would serve the same purpose for the evidence code provisions that the other purpose sections do for the substantive provision.
Okay. In Section 2 of the bill, we get into the definition of criminal street gang, just adding to the language of the existence of the organization, a group of individuals. Again, that's all existing law, may be established, existing law. We add, including but not limited to, common activities, customs, and behaviors. That's pretty straightforward. On the next page, on Section 3, the first, anytime you see criminal street gang, the word street eliminated, that's just for uniformity's sake as to how we're going to go ahead and define the term. We're defining it criminal gang activity as opposed to criminal street gang activity. Line 64 through 66, when the drafting of this bill was going on, and there was a lot of back and forth between myself, Mr. Carlson, and Ms. Travis, as this bill was perfected with about a dozen drafts, I think, which is a good thing. The thought was that given the changes that are being made otherwise in the statute, lines 64 through 67, members of the committee, if you go ahead and try to take those strikes out and read that language, 64 through to 67, I've read it about 28 times now, and I still cannot define what that means. It is just confusing language that will serve the legislature, the people, and the courts not at all. And basically, there's no meaning to it. There's no meaning that I can construe. There's no plain meaning to it, and so therefore it was stricken simply to go ahead and not confuse the statute. There's no substantive effect that I know of and willing to be educated otherwise as to the striking of that language.
No, in our fear, we've convicted about 52 defendants under this statute that never used it and are fearful that if someone does try to use it because of its ambiguity, it would start chipping away at the statute. So we want to be proactive and make sure that the statute is clear at all points as opposed to creating confusion.
Thank you. What we go ahead and do in line 68 and below is we add, we're making some substantive, or proposing some substantive adds in terms of unlawful actions. What we did not have before were committing any offense enumerated in paragraph 1 of section of 1615.3. And those, I mean, I have those here in case anybody wants a list. I think we talked about that at the last meeting. But talking about obtaining, earning membership, adding in on line 75, any other position of management or leadership. A very key component on line 77, I believe, unlawful for any person to cause, encourage, solicit, recruit. A very important thing as it relates to our schools. Mm-hmm. Recruiting or coercing another to become a member or associate of a criminal street gang, or to participate in a criminal street gang, or to conduct or participate in a criminal street gang, trying to go ahead and expand out that definition to really meet what it is that these organizations are doing right now in terms of coercion, recruiting, any actions or reactions that they're having as part of their ongoing criminal enterprise, and what they do to keep going.
That's correct.
Beginning on line 89, this is where we add in unlawful for retaliation, just to summarize, retaliating for refusing to become a member, line 89 to 93, lines 94 through 98. This is the provision where prohibiting retaliation against testimony, testifying against the gang or individual gang members or associates. In J, beginning on line 99, this is the retaliation provision as it relates to communicating with law enforcement, making it unlawful to retaliate, threats of injury or damage to the person, property, etc. I think it's identical language throughout. It's just getting into certain different subject matters, this one having to do with communicating with law enforcement, judges, etc. In line 117, an important provision regarding special conditions of probation. Right now, the court, in its discretion, can go ahead and impose certain special conditions on a case-by-case basis. As I've read and come to understand this, a special condition of the sentence will be that the individual won't knowingly have contact with in any way, shape, or form with a member or associate of the criminal street gang, shall not participate in any gang activity, and shall not knowingly have conduct of any kind or contact, with any kind with any victim or member of the victim's family or household. Again, I think it's pretty straightforward. Section 5, I mentioned that earlier, beginning on line 136. This is where evidence admissible regarding the existence of criminal street gang. We add associate because it's possible for an individual to commit an act that can be used to establish the existence of a gang who's not actually a member of the gang, but can be an associate of the gang. Maybe someone who is trying to obtain membership in the gang.
A member in waiting.
Member in waiting, however you want to call it, through whatever system they have. And that will go ahead and capture that activity. That activity, as a practical matter, I assume, is just as bad as any other act by a member, a identified member of a gang act. It just happens to be done by someone who is not officially a member yet. Section 6, I think, is just a cosmetic change there. Prosecuting Attorney's Counsel. Section 7 gets into the authorization. Section 7 gets into the authorization of the General Assembly to the GBI to authorizing them to establish, develop, manage, maintain, etc., the criminal street gang database, giving them authorization to create the database, sharing information with localities as that is practical, reporting formats, things that we've seen before on other databases, but this would be specific to criminal street gang activity. We did discuss last time that this is authorizing, it's not mandating. If it were mandating, we'd be getting into a fiscal situation. Candidly, the funds are not there right now to go ahead and fund such a database if we were to mandate it. This is authorizing it to occur, and that, of course, is subject to the funds being available to actually do the job. I thought it was important for us to go ahead and make a statement that this is something that we consider to be important. It's authorized to occur when it's funded. When it does occur, obviously, the appropriation on that will have to be in alignment with the wording of the statute. In Section 8, line 186, this is going to provide that only a Superior Court judge can grant bond on a violation of the Street Gang Terrorism and Prevention Act. That's in addition to I suppose 12 other provisions where only a Superior Court judge can grant bond. This would add that to that list. Section 9 essentially says no contact by the individual where there is a victim, no contact between that individual and the victim or the victim's family. Section 10 on the probation supervision, the normal course of probation, as I understand it, in terms of you can have a probation as part of a sentence for X amount of time, but the norm, and I hesitate to use that, and correct me if I'm wrong, the norm is that the supervised portion of that probation is up to 2 years. Is that correct?
That is correct. And if I can, Mr. Chairman, I did speak to Sandy Michaels about her objection to this section, and we do have a proposed compromise, if you will, in terms of time. Okay.
Well, I mean, to me, this is as I see it, it's really a policy matter for the committee to address. This is generally it's a matter of 2 years for purposes of this particular activity, this particular conduct. What the bill provides is probation supervision for the balance for the entirety of probation, as opposed to for any limited time during probation. And as far as I'm concerned, speaking for myself and only myself, I'm comfortable with that. If the committee seeks to do otherwise, I'll certainly respect that. With that, I want to just go ahead and run through that. If there are particular questions from members of the committee, I'll go ahead and do my best to answer them. If I can't, I'll certainly punt over to the DeKalb team, and hopefully we'll have a good dialogue like we always do. Ms. Abdul Salam.
Thank you, Mr. Chairman. Thank the DeKalb team for being here as well. Mr. Chairman, unfortunately, I missed the wonderful presentation last week, so if I'm redundant, you can let me know later. My my concern or my question goes to the ages. This, of course, is not going to apply in juvenile cases, or will it apply in juvenile cases?
It does apply in juvenile cases.
So this will also cross over to the juvenile code rewrite. And I guess where I have hesitation, I'm in favor of the bill, let me say that. My first piece of legislation that I introduced in 2005 was the Trevon Wilson Act. Trevon was a 4-year-old baby that was killed in a gang shootout with 18 gang members. So let me be very clear, I support the bill. My question, though, is that with schools already doing things like the gang watch list, does this lend itself to profiling?
No, it does not, largely because the Supreme Court in the State versus Rodriguez has already outlined that this is not attacking associations. This addresses criminal conduct, and it is the constitutionality of this bill has been upheld mainly for that fact. Throughout the statute, you will see, in fact, I think it's in the definition of a criminal street gang in section 1615-3, it specifically says that this statute does not apply, even if people are associated in fact, unless they commit a crime. So absence that criminal element, this statute will not be invoked.
Okay, and that's my concern. That answers that. Thank you.
Any other questions from members of the committee? Seeing none, thank you. Appreciate your presence then and now. Stick around. Again, in the interest of time, Ms. Michaels, come on up, and we'll be happy to hear from you. And what I may do is, since we've had the DeKalb team up here on the prosecutor side, limit it to you on the defense side. If you want to bring anyone with you, you certainly may. Okay, and that's fine. Aren't we all? Aren't we all? And then we'll go from there.
And I really do appreciate Ms. Keys Fleming a lot working together with us to resolve any outstanding issues. Thank you. Again, we only have 3 small issues with the bill. Well, one's a big one, but the first one on page 2, lines 41 through 44, that I believe some questions were raised in the last hearing we had about that section. Ms. Keys Fleming and I spoke last night, and our concern was that this would be used to, there's a practice in federal court where you can have experts talk about the practice of people, what do gangs usually do. And I understand that the intent on this section was just to make sure that if there's any challenges to the bill, this is the purpose for the bill. And it wasn't to open the door to any evidence, experts. So we drafted some language, and I'm not sure that we've had a chance to sit and talk about it, but we would respectfully request at the end be added, this paragraph is not intended, however, to limit the trial court's discretion to exclude evidence in the event the probative value is outweighed by its unfairly prejudicial impact, or to exclude evidence that amounts to hearsay, or to limit expert testimony that fails to satisfy the evidentiary prerequisites for the admissibility of expert opinion testimony. And based on my conversations with Ms. Keys Fleming, it's my understanding that that section was not intended to encourage expert opinion testimony, and that was the language we offered to make that. This is a hotly litigated issue in the federal courts. The 11th Circuit has not addressed the issue. The First Circuit has addressed the issue and does not allow the opinion testimony. And all the cases, I have the stack of cases with me if anybody wants to look at them.
2 things. I would ask you to pass it over here so we could get a copy of that or give it to Ms. Morris if you would, so members can get a copy of that, and I'd like to hear from the prosecution community as to their thoughts on that.
And we have not had a chance to discuss it.
Oh, okay.
Yeah, we just did it.
Read what you submitted, I was about to say, Your Honor.
No.
We're comfortable with the language as it reads. I think, with all due proposing is more like a judicial instruction, and I think that goes outside of what my understanding this body intends to do. It's just to provide overall explanation as to why evidence of gang activity is admissible to show the presence of a gang. And so I understand a concern about expert testimony. That's not what we're trying to get into, but I also think her language goes way beyond the scope and is
Okay.
It is, I mean, I agree it's wordy, and I'm sure we can work together to cut it down a little bit.
Well, I mean, out of deference and fairness, we're going to go ahead and take a look at that, and we'll just see how that process goes.
The third issue was on page 7. We did discuss the issue about allowing, it's in paragraph 2, where the person is going to remain in supervision for the remainder of the sentence. And we talked, our position is that doesn't allow for the probation officer to use some discretion on those cases where people really do rehabilitate and do leave their gang life behind. And we did agree that a language that would cover the time period so they'd have supervision, but allow for the opportunity for the judge or the probation officer to terminate if they have proven themselves to become a citizen and a good participant in the community. And we agreed upon the no less than 5 years from the imposition of the sentence language instead of until the termination of the sentence on line 207.
Would you say that again?
Yes, sir. On line 207, delete where it says until the termination of the sentence and put it in shall remain in effect no less than 5 years from the imposition of the sentence, period. That gives control, but also the ability to release the person if they've proven themselves worthy. And the remaining issue that we were not able to come to an agreement upon is one I discussed the other day, one that I find very troublesome, is the one on page 5, section 5, lines 136 through 139, the addition of the word associate. I think that's a very bad trend. I understand that the argument was that it's the actions of the associate are not necessary to prove the criminal act, but the membership in a gang. But the whole reason for this bill is trying to convict someone of a crime, and you are allowing the actions of somebody that is not actually in the gang, but just a member of the gang, to be used against somebody else to prove they're in the gang. And I think that's just really stretching it out a little bit too far. I think it's a bad policy decision, quite frankly.
Okay, I can appreciate that. As I read it, it's member or associate of a criminal street gang shall be admissible in any trial or proceeding for the purpose of proving the existence of the criminal street gang and the criminal gang activity. I mean, one of the very few things I retained from law school was that you construe a statute in terms of its plain meaning. And it's proving the existence of the street gang and the criminal gang activity. That's how I'm reading it.
Yeah, I agree, but you wouldn't be doing this if you weren't trying to convict someone of the crime.
But that's separate and apart, and in addition to what has to be proven for the underlying predicate act. It's a separate burden. It's an additional burden on top of the burden that the prosecution has to handle for proving the elements of the predicate act that they have to do in order to get to the gang aspect of it.
I understand, Mr. Chairman.
Is that not true?
I believe the way you're reading that is true, but I think the actual end purpose is to be painted by too broad of a brush of somebody else's actions just to prove they're in the gang. And I think the way it was originally written achieves the purpose that you want and the proponents of the gang bill. And I worked on the original gang bill, so I mean I recall this 10 years ago. But I think adding the word associate, I understand what you're saying. I think we just disagree. And
I think where the disagreement is that there's a realization, I think, on the part of the majority that we're not just talking about members of a gang, that these things occur, that these actions and the conduct occurs by people who are not necessarily members of the gang, but they're affiliates, associates, whatever you want to call it, and they're just as bad. So I mean, I think we'll just agree to disagree on that. Ms. Abrams.
I had another actually.
Oh, I'm sorry. I thought you
objection
were
to
done.
that. The actually other problem I find with that section is there is no definition of associate. I don't know what that means. It's not anywhere in the code section. It's not anywhere in this code section, but it's not anywhere in the code, because I did a word search to see, well, is there something we can know what an associate is?
Well,
I mean,
we have plenty of words in our code that we use that courts rely on and juries rely on without being actual defined terms. Ms. Abrams.
Thank you, Mr. Chairman. And actually, Representative Abdul Salam asked me a question I couldn't answer, and I think this goes to the concern that that's being raised by Ms. Michaels and Mr. Chairman. It's okay. It actually goes to both of your points, and I just am seeking clarification. Given that associate actually has a fairly specific meaning in the Constitution, and there are questions about association, and I deferring to the DA's explanation of why associate was necessary and important. My question is, how tenuous is this word, given that it does have other meanings elsewhere in our constitutional lexicon? And that would be my concern about just putting this word in here without a definition. Because what the representative asked me was, would she be considered an associate if a member of her family was in a gang? And the answer is, I don't know, given the plain reading of the statute. And so I do think there may be some merit to ferreting out, because associate does have a specific meaning in our criminal justice system and in our civil system.
Let me hear from just some input from the prosecutors on what their sense of that is.
Mr. Chairman,
See if we can achieve consensus on it.
I'm going to defer in large part to Mr. Foy, who
Okay.
many of you know is the expert as it relates to RICO. But our concern, if you refer back to the definitions, which is the first part of this code section, you go back to the definitions, the words criminal street gang is defined as an organization or association, someone associated in fact. It's used, association or associated in fact, is used several times in the statute, and they have not been defined. Our fear is that defining them at this, and not been defined in the statute, has been upheld constitutionally absent that definition, because this code section is not about guilt by association. So in Representative Abdul Salam's example, no, unless she committed a crime that helped define the gang. So again, I'll refer to the specifics and constitutionality to Mr. Ford, but short answer is no, and we fear risking putting the gang statute on hold while we determine the constitutionality of the definitions that we
Just to elaborate a little bit, is it all right if I
Sure.
standing here?
Sure. You can come to the microphone if you'd like.
I don't need to if you can hear me.
Absolutely.
That'll save a little shuffling. The word associate is not new to this statute. It was in it when it was originally enacted. It's in other definitional parts of it. So we're not introducing a new concept here. We're not introducing a new concept to this statute. We're not introducing a new concept to Georgia criminal law. The word associate is in the Georgia RICO statute. It's been there since 1980. It was in the federal RICO statute since 1970. When we're talking about street gangs, these aren't Delaware corporations. They are informal entities. They don't get created by somebody else. They get created by people choosing to associate with each other. But there is not evidence that exists of them other than the fact of their association. That's what makes them gangs. They don't incorporate. They don't take office buildings, etc. So in this circumstance, what has happened, I mean, just last year, the Georgia Supreme Court encountered this issue twice and said it is not unconstitutionally vague, that it can apply it. The courts have applied this word and variations of it consistently. The word associate can have different contexts, but in this context, you take the ordinary meaning of it, which means something people do voluntarily, something they choose to do. But they're also associating in the specific context of a gang, and we have a lot of definitions. The Supreme Court really needed only a paragraph to say that was fine. That was something they could understand and apply, and that the lower courts could do the same thing. They did that in Rodriguez, and they did it a month later in KRS. This is really sort of a solution in search of a problem, or a problem in search of a problem that's already been solved. I'm not sure what the most accurate characterization is. But somebody doesn't find themselves in violation of the Gang Act because they associate, because they're members of the same family or they go to the same school, etc. They ultimately have to commit a crime. And, you know, this is, I mentioned at our last hearing, and I won't belabor the point, but there are two kinds of enterprises in RICO cases. One is the formal enterprise, a corporation, an LLC, an LLP, etc. We don't have those in gang cases, so you could just lop that half off. The other half is what's called an association in fact. Associate is the operative word. That's the only word. Every mafia family is an association in fact. I mean, the federal courts have been dealing with this issue since 1970, and federal courts and federal judges and federal juries have been addressing the question of whether a group of people associated for a criminal purpose. They haven't had trouble doing it. This is not some unusual or insurmountable step. It is simply another use of a word that's already in the statute that has not previously presented any problems.
Ms. Abrams, you have a follow-up?
I do, and actually, okay. I appreciate that explanation. And this is a question for Ms. Michaels. Going back to your first concern, lines 41 through 44, can you give me an example of when this would be problematic?
When this language would be problematic? Because it's in the section 1 that's explaining the bill, the purpose of the bill, and the reason why they're drafting it. If you look at section E, right now you can have expert witnesses as to the practices of a gang. What are their history, what are their nature, what are their activities, what are their practices. And as a general rule, what they'll do is have an agent who is familiar with gang activity testify as a gang expert that this is what gangs do. They wear certain colors. They call bricks of drugs, boats. And the problem is that it's an issue right now in the federal courts about how far you're going to go in allowing opinion testimony like that as an expert, as a general matter, as opposed to what they did in this particular gang. And the reading of these 4 lines would open the door to saying that evidence of that could be used, admissible, and the stretches it could be used as opinion testimony. And that's what we're trying to avoid. And my understanding from Ms. Keyes-Fleming is that was not their intent to open that up to that being an expert opinion. It's just to show that this was the purpose of the bill. And the reason why we feel it's critical is because, like I said, it's a litigation area in the federal courts right now, and putting language in there to limit that this is not to open the door to expert opinion testimony. And I agree. I think the language could be a little tighter than what we proposed, but you don't want to open that up. If this is going to be what this bill's all about, you don't want to say, well, they said it'd be okay here, because that'll be what a gang is.
Mr. Carlson, reaction?
Certainly. First, I want to underscore Mr. Floyd's point from a moment ago, and it applies directly to this one. In this statute, the word associate actually is in 1615 for the charging provision, and it was there, and that specific provision was upheld as constitutional in Rodriguez, based on, against all of the arguments of, well, this could be the Cub Scouts, this could be whoever. Now, to look at that in terms of these arguments, no federal court hears and uses this particular statute. This Gang Act is different than what the federal courts consider because it requires a criminal action on the part of both the defendant. Can't get charged with the gang statute violation until you've already committed something that's a crime in Georgia independently. And secondly, that the organization be criminal. So our statute is narrower, and the evidentiary code provisions are narrower. So the purpose section that we're discussing here, A, is not an evidence code provision. The evidence code provisions of the Gang Act allow for 2 things. 1, proof of the activities of the organization in order to prove that the organization is a gang. That's a limited purpose. And secondly, it allows for certain types of evidence to be admitted to prove that. Tattoos, graffiti, those sorts of things. So the question is it the intent in enacting this series of statutes in this act to allow that evidence to be admitted over other objections. And it is. That's why the statutes were there to begin with, the ones that are already there. Now, if those statutes are challenged, as the charging provisions were in Rodriguez, the analysis from the Supreme Court is going to go back to the purpose section. And what this purpose section says is, we intended these evidentiary provisions to have the effect that the plain language say they do. They don't go any further. And the proposed language that we're looking at now, in actuality, would import a different standard there. And let's not forget, when looking at expert testimony, federal courts have a different standard of prejudice than Georgia does. Georgia's a much lower standard of prejudice, so a lot more evidence can get excluded. But the other factor is, none of those cases cited here, and the ones that interpret them by Ms. Michaels, exclude expert testimony in gang cases. Expert testimony in gang cases is allowed. Expert testimony in gang cases is already allowed under Georgia law and has been for over 20 years.
And has that been affirmed through the Supreme Court?
Absolutely. In fact, cases I've handled, in particular, as far back as '99, and I was relying on precedent from before. So again, effectively, the purpose language is being suggested, as opposed to what you're looking at now, would actually disable the evidentiary provisions that we have. The language that you're looking at here, currently in the statute, or in the proposed statute, would make sure that those remain an effective challenge. Just like the purpose sections pertaining to charging protected the charging provisions from the constitutional challenge in Rodriguez.
Mr. Vice Chairman, and then Mr. Franklin.
Thank you, Mr. Chairman. Is this the language that y'all are proposing?
Yes.
It's being handed out? Okay.
Yeah.
Mr. Carlson,
Yes.
I wanted to follow up on what you were saying. You started out by saying this is not an evidentiary, this is not intended to be an evidentiary provision of the bill, correct?
Well, what's I guess at lines
41 through 44.
41 through 44, yes. That in and of itself is not an evidentiary rule.
What I hear Ms. Michaels saying is that the concerns are that this would be a provision that would be used to supersede the normal sort of gatekeeping test that we have for any evidence to be admitted, and that is whether or not its probative value is outweighed by the prejudicial effect. And I guess my first question is it your intent that that test would not come into play with regard to any of these factors concerning criminal gang activity?
Well, there's a two-part answer to that question. With regard to the limited purposes that the Gang Act currently has, and we're talking about current law here. We're just talking about adding a word to the current law and a purpose section behind it. Okay? With regard to those limited purposes of proving that something's a gang, the specific statute would override the general ones.
Okay.
Yes. Okay. However, for any other purpose, for any other reason that gang-related evidence would come in, other than to prove this is a gang, it would be subject to the same analysis that we have under the law. So in other words, if we go to 1615.9, which is on page 10, 136 and 139.
There's not a page 10.
Where are you?
Section
I'm
10?
sorry, I may have an earlier version here.
Section 10. Is that what you're talking about? That's the probation.
No.
You're looking at page 5, section 5.
Okay.
Section 5.
Okay.
Now there is a limited purpose in cases charged under this set of statutes that gang-related evidence is admissible. A limited purpose, and that is proving that this organization in question is a criminal street gang.
But
okay? The evidence offered for any other purpose would be subjected to a relevance, trustworthiness, and prejudice analysis.
So basically, if if these items are being offered for those purposes, they will not be subject to any other scrutiny for that evidence normally is with regard to trustworthiness.
Well, it would still have to get through all those thresholds. It would still have to get through all those thresholds, and you'd still have due process limitations on it. But it wouldn't be subject to all of the same objections, no.
Okay. I'm sorry, go ahead.
I was going to offer to try to clarify. I think one of the things that we need to keep in mind with this statute is that it adds to the prosecutor's burden of what it must prove to be successful under the statute. One of the slides that we showed was a triangle. Normally in any crime, we just have to prove this defendant committed this crime. But under this statute, because of the crisis that this body or the larger body has seen with gang activity, they added that third point of the triangle where we have to be able to prove the elements of a criminal street gang. Raising our burden, at the prosecutor's burden, the legislature in 2006 saw the need for us to be able to present evidence of the gang itself, whether it's tattoos, the violence, customs, whatever it is, done by members or now proposed associates. So in order to help us meet that higher burden, again, to keep all of our streets safe, they allowed for the evidentiary provisions of getting in things that established, factual evidence that established the gang. And so now we're just asking that the intent that put Section 1615.9 into place just be formally put in writing. There was a reason you wanted to, and I say you not to be disrespectful, but this body wanted to be able to allow prosecutors to bring in evidence of gangs to establish the gang itself. That reason, we don't want it to be unclear. And so we proposed language to try to clarify that to give the courts direction.
I would argue that the reason that you need that provision is to get around existing law with regard to other crimes, wrongs, other bad acts, that these items may not be admissible under existing law, but just because you've got a burden connected with proving these things, and just because we're specifically saying that these items would be admissible and can be admitted in order to satisfy that burden, I don't think that, at least from my standpoint as a legislator, it would not be my intention to drop the normal protections, evidentiary protections that any defendant has with regard to making sure that the evidence that is admitted is reliable, that it's trustworthy, that it has that its probative value outweighs its prejudicial effect. And with regard to expert witnesses, I can't imagine that we're going to say, just anybody is going to be able to walk in. I know the federal courts are not going to allow just anybody to walk in and be admitted as an expert, and be able to testify to these things without going through the normal qualification procedures as an expert.
Well, they're still requiring that of us. They've not just kind of thrown out the whole evidentiary provision anytime we come in saying this is a gang case. So they still put us through the paces.
So, but are you just saying that you don't think that these normal protections are being thrown out the window through this, but you just don't see a need to go into to have the additional language that is being proposed?
That language, and I don't have a copy in front of me. I'm going from memory from what I saw a little while ago. I think it is very restrictive in terms of mandating what a judge should or should not do. And again, we would be more comfortable leaving it to the judge to decide. There's nothing in this code section, either as proposed or as it stands now, that tells a judge to throw out all evidentiary considerations and things. They still, even as they get educated on it, they still, like I said, put us through our evidentiary paces.
But I would beg to differ, because I think when you read the proposed language and it says shall be admissible, that word in Georgia law, as you know, is directory and is taken literally, and it could be that you might change that to may be admitted.
That language was already in the statute. It was already in the statute from 2006. So
okay.
So what's in the purpose section reflects what's already in the Gang Act, and so we actually.
Well, has there been, I don't mean to interrupt, but has there been a decision that has construed that particular section of the Gang Act where that issue has been raised?
No, not specifically, which is why we're examining adding the purpose section now. Again, we haven't had a challenge in prosecuting a wide array of these cases and having a pretrial brief that we submit in every single case regarding these issues of evidence. And remember, what was done in 2006 with codifying 1615.9 was codifying rules and common law that had already existed in Georgia and had for decades. So again, these issues have been vetted by our courts. However, the insurance there was in order to have a functional gang act, to deal with what was called a state of crisis, to have evidentiary code provisions that would allow the jury to see the full picture and breadth of the organization's activity, which is exactly what was done with RICO. Again, not one successful mafia prosecution before 1970. What changed? Not bigger penalties, but the fact that juries were able to see under the RICO statutes exactly where all the connections were with the mafia.
I understand, and I understand what the underlying point is of the statute. I agree with the bill. I support the bill, and I support the need of the prosecution to be able to admit the evidence relating to the customs or practices, the nature of the criminal street gangs. I don't have a problem with that, but I do. My concern, and I think I'm echoing the same concern that Ms. Michaels is stating, is that we don't throw out all of our evidentiary standards, whether purposely or unintentionally, in trying to make sure that the prosecution can get this evidence in.
Let me ask a follow up to that.
Sure.
What's the harm in some? I'm not saying that Ms. Michaels' language is the language, but what is the harm of a restatement to Mr. Hatfield's point? I mean, we can say that shall be admissible subject to X, Y, and Z.
I think with regard to adjusting what we're looking at now in terms of the bill versus what's been suggested by Ms. Michaels, if the additional language perhaps could say, for the purposes enumerated in this statute. In other words, shall be admissible for the purposes enumerated in this statute. Now, this is not a similar transaction provision. However, think about similar transactions come in with a limiting instruction. Now, on behalf of the office, I have, Mr. Floyd have, we work with prosecutor's office, investigators across the state have always recommended a limiting instruction, that DAs ask for a limiting instruction in connection with 1615.9. So, again, in terms of altering it up front, what's the intent based on what the statute we have in existence says? So, for those purposes, that evidence would be admissible. Not for those purposes, that evidence would be admissible and subject to, what's currently otherwise a common law prejudice. Because for the most part, and this is consistent from California to Illinois to here, the biggest success that gang members have had in trials in getting acquitted is the inability under many states' evidence codes to be able to show the full breadth of the gang's conduct in order just to prove that this group is a gang. Because the first line of defense under this heightened proof standard that we have is, this is not a gang. We're not a gang. Because remember, once prosecution indicts under this statute, we have to prove A, the underlying crime, B, the existence of a criminal street gang, C, that this defendant was a member or associate of that criminal street gang, and D, that there was a connection between the gang, the defendant, and this offense. None of which we would have to if we just charged the murder, and then perhaps could still get the evidence of the gang activity in if it went to motive, or it went to connecting the defendant.
I think, Representative Abrams has passed around a note here to me that suggests, and I think where she's going with this, if this is not intended to be an evidentiary section, she suggested line 42 that if you strike the words, it is necessary to ensure that, and then line 43 change the word shall to should. And if this is merely a finding or statement of policy by the General Assembly, am I right? That language should satisfy what we're attempting to do here. What do you guys think about that?
Let me ask Mr. Get to Mr. Franklin. He's been very patient. Maybe you could go ahead and restate. I'd ask the Vice Chair to go ahead and restate that. Take a look at it. I want to recognize Mr. Franklin for his line of questions, and then we'll move on from there.
Line 42, strike, it is necessary to ensure that, and line 43, change shall to should. And again, that's Representative Abrams' amendment. Good job.
Mr. Franklin.
Thank you, Mr. Chairman. Ms. Michaels, on the when the prosecution was talking about the word associate on line 137, they actually defined that reading the sentence coming down from line 137 by any member or member in waiting. It being that seems like the intent is to grab those who are seeking to gain membership. And would you believe that rather than using the word associate, we would go with the intent of the promoter of the bill, that they're wanting to grab those seeking membership rather than just the word associate? Would you have any thought on that?
That is what they told me. They were.
Right, but as far as rather than using the word associate, use
Member in waiting?
or either member in waiting, if that's got a that seems like something out of Shakespeare possibly.
Well, this could be a Shakespearean,
or someone seeking membership a person seeking membership might be a better term. But
let me offer this. What we don't want to do, I think, just expressing an opinion, we don't want to do is have language that is too limiting.
Mm-hmm.
An associate can be someone, and again, it's throughout the code and has been used in the statute already and has been upheld. The purpose there is to not limit it just to member or member in waiting or whatever the euphemism may be, but you may have individuals who are with the gang who may not actually be members of the gang. And by using the word associate, you're able to go ahead and cast enough of a net to catch the bad guys who may not actually be members, because if you confine it to member, it's too confined. You're going to have conduct that you can use to go ahead and establish. Again, this is to improve the existence, as per the language of on line 138, proving the existence of the criminal street gang and criminal gang activity. If you limit it just to member, then you've got activity that you could otherwise use to establish the existence that you can't use because it's not there.
Right, that's why I was saying instead of using the word associate, member or a person seeking membership in, something like that.
Well, my personal reaction to that would be is that also may be too limiting, because you may have people who are associated with the gang who are not necessarily members, and they're not necessarily people who actually want to be members, but they are people participating in that otherwise grander, if you'll forgive the term, criminal enterprise. And that's the intent there, just to make sure that's clear. But
okay, and another question for Ms. Michaels on your proposed language on page 7, the lines 205 to 207, or actually probably I think you're just changing 207. With the 5 years, is there a possibility that a sentence could be less than 5 years that I'm missing somewhere, that we're saying they're got to be supervised by, if we say that it's 5 years or not less than 5 years, could we be saying there's the potential that they would be under supervision longer than their sentence? Is there a possibility of a sentence greater than 5 years for this offense?
that goes to the issue of the
less than 5
sentencing
years?
for the offense itself.
There are a few offenses in which the minimum is 3 years, and perhaps the way we could word it is the term of sentence or not less than 5 years, whichever is less.
Yeah, that was a concern, that we would be having them supervised after their sentence had expired. And if just one other thing that just came up on this last exchange with the Abrams-Hatfield amendment is rather, I'm not certain of too much of a difference between the word shall and should, but would may be admissible, be satisfactory?
We would object to may, but we can live with should.
Is that pretty much the reason why? Because
What if I object?
You may, Ms. Abrams.
I specifically chose the word should. Shall has no leverage. I mean, shall is an imposition of an imprimatur. May is, I think, too permissible given the language you're going for. Should suggest the behavior that is intended but is not absolutely required by the actor. So.
Ms. Abdul Salam.
Thank you, Mr. Chair. My question goes back to page 2, lines 41 through 44, where we were talking about evidence and the expert testimony. And I guess the question that came to my mind was some of the best experts that we have out there in this area are former gang members or leaders of gangs, the OGs. Would they be allowed to testify in this instance?
I think it would depend on the fact patterns. Certainly, we're not opposed to that. We would look at, and depending on the facts, any viable option to be able to establish the elements of the crime. I don't think we have used that in the past. Most of ours have been law enforcement officers like Detective Lyda, who might be out in the hallway, who've been doing this for years. Or like Detective Silva, who was here, I guess, last week and talked about his previous gang experience and how he has been reformed but can still speak to the cultures and how gang members are trying to go underground, if you will, not wear as many tattoos and some other subtle customs. They're trying to become more subtle. That possibility still exists.
So the expert testimony is not limited to any particular type of person.
And we never intended this to be directed at experts.
Okay.
It's to establish if we have other gang members or associates providing testimony against the lead people that we are going after. It was family members who see graffiti and things, books of knowledge that are found during search warrants in their various rooms. It was the whole span of evidence that is available to us, not just experts.
Thank you.
Here's what I want to do. The good debate on lines 41 through 44. I think it warrants holding the bill until the next meeting over the weekend to see what we can work out in terms of comfortable language. I don't sense that there's a consensus comfort level on it right now that still gets us where we want to be. We have time. We need to use it. I want it to be right. We want it to be right. The probation, on the probation supervision, I think that's ultimately an easy fix, language-wise. I do want to visit with, the prosecutors and the folks from the defense community and Ms. Abrams and Mr. Hatfield, and get to a meeting of the minds on it. I think we'd be well served to do that. My sense is that we'll go ahead and attempt that in the next few days with the intent of, I think our next meeting will probably be 1:30 p.m. No, it won't. It'll be, I was about to say Monday, but we're going in at 1 o'clock on Monday now. That it'll probably be, it will be Tuesday or Wednesday. It'll either be Tuesday at 1:30 or Wednesday at 1:30. That depends on the jockeying for the room that Chairman Willard and I do. But we'll work that out. It'll be Tuesday or Wednesday, and I think it's time well spent for us to go ahead and just revisit that and see what agreement we can forge on that.
Thank you.
That would be the wise course. I hope the wise course of action. Thank you very much for your presence and for your testimony. That was a productive dialogue. Let's turn our attention to House Bill 927, Representative Jacobs, who's been very patient. Thank you.
Does this mean I have to stop working on my bill that's before the Insurance Committee, Mr. Chairman?
I tell you, we're all multitaskers, aren't we? Let's hold on a second. Let folks file out so we can minimize the buzz.
Pass over.
Representative Jacobs, what I'd ask you to do is obviously make whatever opening statement you'd like, but what would be, I think, most productive is to just go through the bill section by section. This came through Representative Setzler's subcommittee.
That's correct.
Okay, this would be the time where I would go ahead and ask him to make a report on the bill, which I may do when he walks in the room. But absent that, what I'd like you to do, to the extent that you can, is tell us why we're here, give us an overview. As you're going through it section by section, it's obviously not a lengthy bill, but when you're doing that, to also give us a flavor of what changes were made as a result of what debate went on in the subcommittee. That, I think, will give members of the full committee a full picture of what's changed and why, and I think that'll be helpful in terms of expediting the debate and the review.
Sure.
Okay, thank you.
Okay. Thank you, Mr. Chairman, members of the committee. I bring before you today House Bill 927, which is an anti-bullying bill. Let me, first of all, just explain how this issue became an issue that I was interested in, and then I'll go through the provisions of the bill. There was a relatively high-profile case by Metro Atlanta standards in DeKalb County of bullying in one of our elementary schools, where ultimately the young man who was bullied committed suicide, and it's a case that has been involving a young man by the name of Jaheim Herrera, who has the case has been all over the news. And around the time that occurred, I was contacted by more than one constituent and asked to take a look at the state's bullying law, and is there something more we can do? And I took a look at the existing code section, which is the one that is revised by this bill, 20-2-751.4. And found it to be inadequate, and I'll explain how that is as we go through the bill. I should also mention that in carrying an anti-bullying bill, I am not treading upon new ground. The most recently, or the bill that has gotten the furthest through the legislative process, was in 2008. Bill carried by Senator Chip Rogers that passed the Senate unanimously. Went to the House Education Committee, made it all the way through the Education Committee and to Rules, and did not make it to the House floor. I should also mention, in talking about that bill, that a lot of the provisions of this bill are largely modeled after that bill. In addition, the Chairman of the Majority Caucus, Representative Sheldon, has introduced an anti-bullying bill this year. She is a co-sponsor of this bill, and we have talked about this legislation. And the Minority Whip, Representative Hughley, has worked on this issue extensively and has actually introduced several bills in the past on this subject matter, and I've discussed it with her as well. To go through, I've also passed out, the other interesting thing about this issue is that once you begin talking about it and delving into it, and that becomes public information, you start to see news stories pop up, and people start contacting you with their personal stories, which is something I have found interesting and in many ways touching. But this is an article that actually was published very recently, I believe February 1st, in the Times-Georgian, which is the local paper out in Carrollton. And it's actually an article about a group of administrators who are very interested in seeing some revision of the code section dealing with bullying in public schools. And I found it to be actually a very enlightening article, and that's why I passed it out to members of the committee. All right, so getting to the provisions of the bill, again, we're working from LC 29-4096S. Section 1 of the bill is a provision, and I'm just going to go in order. Section 1 of the bill is a provision that was added to the bill in subcommittee. It is meant to, when we get further into the bill, you will see that there is a requirement that the Department of Education promulgate a model anti-bullying policy that can be adopted by local school systems. I also one other general comment before I go to Section 1. In putting this bill together, I was very, very sensitive to the issue of local control. At the end of the day, I do believe that state law in this area does need to be strengthened, but it needs to be strengthened in a way that respects the local control of local school systems. And so what you'll see here is an effort to improve upon this code section in a way that respects the right of local school systems to govern themselves in the way they see fit, but giving some extra tools to both parents and local school systems to deal with what is becoming a prevalent problem in the public schools. So back to the discussion of the provisions of the bill. Section 1 was included in the was added in the subcommittee. And it is meant to make clear that the model policy, which is provided in provided in subsection C of the bill, is not meant to be a definition of the exclusive standard of care the exclusive standard of care for purposes of a civil action that school systems absolutely must abide by. Basically, in respecting local control here, we don't want the Department of Education to put a model policy on its website and then have, after an incident occurs, someone stand up and say, you had to do this, and because you didn't do this, you are negligent. So Section 1 makes it clear that the model policy is not meant to be a definition of the exclusive applicable standard of care for purposes of a civil or administrative action, but rather is meant to be a resource for school systems. Subsection A of the code now we're getting into the code section. Now, there is existing code already in this area, and I need to make that clear. We are just revising that code section. Subsection A is the definition of what bullying is, and the way we have revised that definition in some ways narrows it, and then in some ways recognizes that the current definition of bullying in the code is inadequate and doesn't capture all of the circumstances in which bullying occurs. So we have modifying language now in the beginning part of subsection A that makes it clear that the reach of the public school systems is only to school property, school buses, school bus stops, and significantly electronic technology of the school systems. We are seeing a lot more of bullying incidents occurring via texting and things of that nature. Now, mind you, the reach of the school system should not go extend to a situation where you've got a kid on their cell phone texting outside the school setting another child on their phone. So we're limited. We're being clear about what the proper reach of the school system is, and that is school property, school buses, and school electronic school equipment. Then in paragraph 3, we are expanding to some extent the definition of bullying. Now, I will say that by and large, this paragraph 3 is modeled after what was in Senator Rogers' bill. It has been perfected by the subcommittee, and it has been perfected by the subcommittee in a way that makes it clear that the definition of bullying is not that bullying is not something that is slight. It's not a paper cut. It's not anything minor. It is something. It is substantial damage to someone's property. It is substantially interfering with a student's education, etc. You will see modifying language in each one of these subparagraphs. And then with regard to physical harm to a person, we have, or to a student, we have roped in the definition of visible bodily harm that is contained in the battery statute, and that was in looking at a way to define that. In looking for a way to define that, after getting some feedback from the subcommittee, Jill Travis and I hit upon that definition. I think it's a good definition to be pulled into this paragraph. Then paragraph B is a mandate that exists in current code. Paragraph B is a mandate that exists in current code, and we are modifying it in really only two ways. And then there's a provision in here that actually kind of reflects what the current state of the law is. One way that we are modifying the mandate, and what subsection B says is that local school systems shall adopt an anti-bullying policy. And so every school system in the state has adopted one. We are changing that to say, first of all, that anti-bullying policy has to cover all grade levels, not just 6 through 12, which is the current law. The current law says it's 6 through 12. And of course, the incident that I mentioned to you was an incident that occurred in elementary school. So I think we have to acknowledge that bullying can occur in grade levels that are not just 6 through 12. And then the second part is that has been changed or added is there in paragraph 3, that when there is an incident of bullying, the school system shall come up with a method of and make as part of its policy and promulgate as part of its policy a method for notifying the parents or guardians of the students involved. What has been added to paragraph 2 is actually this was a little different as presented to subcommittee. As presented to the subcommittee, but it has been substantially changed to just reflect that, and I'm talking about what's on lines 41 through 46. It has been substantially changed to reflect what is current policy. That local school systems when there is a severe incident have the ability to transfer a student from one school to another. There are due process considerations, and there's an administrative proceeding that is provided for in the code, and that school administrators can, on an incident of bullying, transfer a student to another classroom. Now, the reason we're making this express in the law, in this code section, is to let parents know and let stakeholders know that that these options are out there. Because right now, the code section reads that on a third incident of bullying, the student shall, and we've modified this to say 6 through 12 because alternative schools only exist for grades 6 through 12, that the student shall be transferred to an alternative school. So right now, the bullying code section itself only addresses what happens in a 3 strikes and you're out scenario. And we want to make clear in the code section that there are other options available if it appears that simply separating the bully from his or her victim would be sufficient to address the situation at hand. So really, at the end of the day, the language in lines 41 through 46 is a restatement of what can be done already. Then when we go down to subsection C, this is the model policy section. Each of these provisions is very similar to a provision, or these are very similar provisions to what was contained in Senator Rogers' bill, with this difference. His bill would have added all of these provisions to the mandate, to what is subsection B of my bill. So I feel that it is better, a better approach to have the Department of Education promulgate a model policy that then parents can take to their local school systems and say, we want you to take a look at this, that we think this is good, the work that they have done is good, that they have pulled in experts in this area. The department has pulled in experts in this area, and they've come up with a good work product that we think you should take a look at in deciding how you are going to structure your anti-bullying policy. Now, because we have, I should also make a quick note about the dates here, the date on line 55 and the date on line 34. If you look at subsection F, current law contains a stick, okay? And the stick is that if you don't adopt an anti-bullying policy, that is grounds for losing state funding. Now, we're changing the mandate a little bit. We're requiring that the policy apply to grades K through 12. That's the one change. And then the second change to the mandate is that you come up with a way and you make part of your policy a method of notifying parents who have been involved in an incident. And because we're making that change, if this code section were just adopted without a date in here, school systems would automatically be out of compliance. And so we have to have some date in the future for school systems to update their policy in a way that complies with subsection B, and that date here on line 34 is August 1st, 2011. And then prior to that, we require the department to come up with their model policy by January 1st, 2011, so that it will be in existence by the time school systems are revisiting their anti-bullying policy. I will say that I have already heard from the Department of Education on this bill. They are supporting it, and they have reviewed the part of the bill that they are responsible for, and are comfortable with being able to do what is are already equipped to do what is what would be required here. And then in subsection D, there are some very good anti-bullying training programs out there. If you just do a Google search, you'll find a bunch of them. And as part of what the Department of Education compiles and posts on its website, we'd also like for them to compile a list of programs and materials that are available for use in public schools that meet whatever specifications the department might deem appropriate. And again, that is something that they are comfortable with. And then finally, subsection E. Subsection E. Again, we want parents, we want folks with information about bullying incidents to feel comfortable coming forward and reporting that information. And so there is an immunity provision in here. It requires good faith, as you can see on line 78. And, of course, the liability we're talking about here, we're not talking about damage to person, damage to property. We're talking about slander, libel, defamation type claims. And I would think that at the end of the day, if you have a report that is made in good faith, that ultimately doesn't pass muster in terms of reporting a true bullying incident, that will be dealt with appropriately in the school systems. But we do want students, teachers, parents who have information to feel comfortable coming forward without fear of retribution. And with that said, and I'll also say I did work on the language in both subsection E and section 1 with GTLA, just to make sure that I wasn't treading on it. As a matter of fact, they're entirely comfortable with subsection E. It's along the lines of what we see in the child abuse statutes.
Thank you, Mr. Hatfield.
Thank you, Representative Jacobs. I start out with the initial observation that this bill sort of smacks to me of the attitude that we can legislate something to basically solve all ills of the world. I mean, there's a certain part of growing up, I think that everyone goes through in attending school, that you're going to come in contact with people that you may not get along with. People may not like you. You may not like them. There are going to be incidents that happen over the course of a child's lifetime that are not going to be pleasant, but they're all, everybody probably in this room has had those sorts of experiences. But what concerns me is this is sort of the, for lack of a better term, the sort of nanny state legislation that kind of, it makes me think, we're setting out to try to legislate to cure, this set of ills that pretty much is common to everybody. But having said that, as a general concern, I wanted to mention a couple of specific concerns that I have on this. Number one, on line 39 on page 2, and this is repeated another location, I believe, on line 49, but it talks about each local board policy shall require that upon a finding that a student has committed the offense of bullying. Okay, my reading of this bill is there's no statement of who makes such a finding, and when I go further down and I read, although you talk about in lines 40 and 41 about a 3 strikes and you're out sort of scenario where you would be assigned to an alternative school, I do also read on lines 43 and 45 where an administration is going to have the ability, based on 1 or more offenses of bullying, to assign a school either to a school outside of the student's attendance area or to another classroom. And going back to the word finding, there's no definition of who makes such a finding, and I think that it creates the possibility of some very inequitable results, because based on one simple report, which may or may not be true, from a student or a parent making a complaint against another student, a finding could be made by a single administrator or teacher, I would submit, that would result in a student being taken and uprooted from the school that they attend, that they've grown up in, that they go to the other, that they have their friends and their relations there, and being put in an entirely different school. That, to me, seems fairly severe for something that may be a fairly minor incident. I also note that in the lines 27, we talk about the term visible bodily harm, and I looked up, that's under the battery statute, and it says, as used in this code section, the term visible bodily harm means bodily harm capable of being perceived by a person other than the victim, and may include, but is not limited to, substantially blackened eyes, substantially swollen lips, or other facial or body parts, or substantial bruises to body parts. And I'm not so sure. I've handled a lot of criminal defense cases where people have been prosecuted under the battery statute for visible bodily harm, and it was nothing more than perhaps a red mark on their face or on some body part. There's a certain amount of normal contact, that when kids have contact, they're going to do things. I know, when we were children in elementary school, you'd have kids that go around and thump the other person's ear, or, they might put a sign on somebody's back that says, "Kick me," or something like that. Things that, at the time the kids think are pretty funny. Maybe that would be construed as an act of bullying under this statute. And I just, I'm not condoning that, but I'm also suggesting that, we need to be realistic in our approach to things that go on, things that happen in a school setting between children. And I have concerns about something major some major action being taken against them, such as uprooting them from their classroom or their school setting based on an isolated incident of something that really may be, in the overall scheme of things, a fairly trivial incident. With that, I'll shut up. If you'd like to, respond, that's fine.
Well, that's a mouthful, and it might, I will say, first of all, I think we can deal with the finding issue by tightening up that language, although I shouldn't, or by adding language that, ultimately respects the local control of school systems, simply by saying that it's a finding, by, this is not suggested language, but a finding, by whomever is set forth in the local school system policy. I don't view that as a problem at all. I think we can tighten that up pretty easily. Although I should note that's language that's found in existing code. So we'd be tightening up existing code, and I don't disagree with you that that might be a good thing. With regard to the the transfer issues, I think I need to reiterate that the language on lines 41 through 46 is really just a restatement of what school systems are already empowered to do. And I think that we have to recognize that we have purposefully set forth in lines 26 through 33 heightened standards. They're not meant to, we're not, talking about at the end of the day a slight incident that is going to prompt these consequences. So there's an extent to which I disagree with you there, although I am open to tightening up the definition if that's something that the committee feels needs to be done.
We'll take a look at, for example, line 29, causes substantial damage to another person's property. Okay, in a school setting, more than likely you're not going to have, most students are not going to be carrying around any property that has a great deal of value, you would hope. But so you might have some individual item. If they got a notebook and somebody rips it up or something, then that's substantial damage to an item that may be insubstantial, but under this definition that you're setting forth, you're going into a lot of technicalities here and findings that have to be made, and what I'm pointing out is that there's a lot of common sorts of occurrences that probably would fit within some of these definitions, and I don't know. If the committee wants to travel down that road, maybe those are some things we need to look at and sort of tighten up. But it concerns me that there are some pretty significant consequences for what may be insignificant sorts of actions. And I'm not in any way making light of students who are victimized by bullies. I think that there's bullying and then there's bullying, and you brought up an incident in a local school system that obviously got to an entirely different level. But my contention would be, or my hope would be, that under current laws and current guidelines that our school boards have and local schools have, that those types of incidents could be dealt with in the school setting without having to enact an entire new set of regulations. But I'll let you, Mr. Chairman, go on to someone else.
Ms. Burton.
Thank you very much for your bill. I would have to concur with Representative Hatfield. I realize that as a child, I was considered part of bullying, if that's what it was, and I bet a lot of other people in this room were as well. Where do we draw the line? Certainly on line 30, I'm concerned about the definition of interfering with a student's education. Each child deals with mental things in a different sort of way. So how are we going to define what a student's learning is? So that's one question. What about special ed students that are in school? A lot of them take special medications, and they tend to get into tiffs in the classroom. That's another concern. And then there's the third concern that I have. There are teachers that tend to favor, as a former educator, you tend to favor one child over another sometimes. You like them a little bit better because of X, Y, Z. So what happens when a teacher makes the decision that something's going on in the class and she really doesn't like that particular student? Well, let's put all the blame on that student as opposed to both of them getting the blame. So I have some concerns about this, your bill. If you could address maybe some of these things I've asked, please.
Well, I mean, I think I think you have to acknowledge that you know we're not dealing with an issue that is black or white. Okay, and it's going to be difficult to come up with a black and white definition of what bullying is, and that's where I trust the local school systems to deal with. And my bill is one that inherently trusts the local school systems to deal with this issue. I mean, we're only requiring that they. I mean, at the end of the day, we're only requiring that they adopt an anti-bullying policy, that adopt an anti-bullying policy that applies in grades 6 through 12, that causes the transfer to an alternative school, and that's existing code, okay? In a 3 strikes and you're out scenario, that's existing code, okay? And then notify the parents when an incident has occurred. Now, I think that approach, requiring the school systems to just adopt a policy that they can then apply, on the deals with the other side, helps address the other side of it, and that is that, defining what bullying is not something that is a black and white situation. However, as we have made clear throughout this definition, it is something much more than slight. I mean, we have modifying language throughout this definition that makes it clear that it is a heightened or extreme situation, where bullying really is coming into play. So I just want to be clear that at the end of the day, there is a lot of discretion for the school systems in what is existing code, and frankly in what would be the new code section. But we are giving parents and local school systems some additional tools to deal with the problem, and that, to my mind, can't be a bad thing.
Further comment? Certainly, there are parents that have real issues themselves, which of course then their child is mean, they're ugly, they do these kinds of things. I mean, are we going to ever be able to stop that? I don't know.
No,
but this is my concern about this bill.
Well, I don't. You cannot bring forth a bill that completely stops a problem, and I'll admit that. I mean, I don't. But that doesn't mean that this bill is inherently flawed. I mean, I think it helps school systems and parents address a very real problem in the schools.
Ms. Mayfield.
I was just going to, whenever appropriate, ask that we make a motion, but I understand that Representative Ramsey is ready to do so as well, and you can recognize him for that when appropriate. I do want to thank Representative Jacobs. He's been very open in this process. He met with me and some other representatives to address our concerns with the bill, and I'm just very pleased with the end result.
I think what I'm inclined to do, just for purposes of notice, is along the same lines of what we did on the previous bill, is to hold it until the next meeting where we will have a markup and we will have a vote. There are some concerns, and to the extent that those can be addressed, maybe they can, and maybe they cannot. And if they cannot, then we'll just go. The process will work one way or the other. I think that might be the best course of action right now. But we will get to a markup and we will get to a vote early next week. I think I'd be remiss if I didn't allow for the possibility of the curing of those concerns in order to forge consensus on the committee. Again, we have the time. We ought to use it.
I appreciate that.
Yes, ma'am. Mr. Franklin.
Thank you, Mr. Chairman. Just to preface my comments with what you're saying, before we cut off and the markup gets done, would there be the possibility for some comments from some in the audience?
Oh yeah, and we'll have testimony just to make sure that it's clear. We have Q&A from the author. We will have testimony, right, and then we will have markup after that. Now, in the interim, it just depends on how long the hearing goes today. Right. As a practical matter, to answer your question directly, there will be testimony just like there is on every other bill.
Great. Just
for purposes of process, I just wanted to make sure people knew what was going to happen and when, but it'll all get done.
Great, thank you.
Yes,
and just in addition to preface the comments to Representative Jacobs, this bill reminds me a lot of my first term down here, and Chairman Cooper might remember Randy Sauter's teen driving bill. That anecdotally there was a tragic accident where some teenagers were killed after vandalizing a neighbor's yard and then fleeing the scene of that crime with their lights off, came upon a hairpin turn, hit a tree, and a number of them were tragically killed. I think some of them were actually in the trunk of the car, if my memory serves me. That was a long time ago. And obviously, headline tragedies do make for bad legislation after the fact, and because we can't fix everything, as you acknowledge, we are not the people's savior. We cannot pass a bill that ends. Even this will not end bullying. That teen driving bill did not end teen driving accidents, and it's just a matter of really what is our proper role. And piggybacking on Representative Byrd's question on line 30, I've got one on line 31 I would like to ask, and that's how are we defining intimidating? So where you might have a persistent where an act is so persistent it creates an intimidating educational environment. Could that be the person saying, "Hey, Four Eyes," day after day after day? Who picked your clothes today? Day after day after day. Is that bullying? Is that just being rude? Just wondering, how do you define intimidating? How will a court define intimidating?
Well, of course, it's not a court issue.
It's not a court issue. I mean, this is an issue in the education.
Right. Well, how will the educational court, so to speak, in determining whether this is bullying, how will they define it?
Well, a lot of this is going to be left up to the discretion of local school systems.
Mm-hmm. All right, and
I'll repeat that.
Mm-hmm. All right,
numerous times.
Line 46, the very end of it, we have the word victim. What if I go to the principal and say Mike is bullying me? Am I a victim, or am I just an accuser at that point? Would you be amenable to change the word victim to accuser till it is established that you're a victim?
Well, I mean, again, this is not victim in the criminal sense, Representative Franklin. It's victim for the purpose, and ultimately, okay, I mean, not putting aside the issue of a school administrator transferring a student to another classroom. Okay, there are all kinds, with regard to the transfer to another school, there are all kinds of due process considerations, and you actually have to go through an administrative hearing type process, where findings are made and everybody has an opportunity to be heard from. So, I don't think that's an arbitrary, willy-nilly use of the word victim there.
So this part in paragraph 2, use of the victim, would be after that, where it has been established that the bullying has taken place.
Where are you pointing to?
On line 46. So this whole thing on paragraph 2, from 39 to 46, only applies after all this process has determined that bullying has indeed taken place?
Yeah, it says upon a finding.
Okay, great. And on line 57, or 55, develop that model policy regarding bullying. And on line 57, such policies shall include. These are just minimum things that we're telling them that has to include. Is that right? Just so long as it includes this, their policy, we're not telling them they can't put more stuff in there. Is that right?
That's correct.
All right. Line 74 on the next page, we've had several bills so far this year on the floor where we're making sure that a person doesn't actually have to publish; they just make available to save printing costs. Have you thought of maybe a different word than publishing on line 74?
It doesn't necessarily. First of all, publishing. The use of the word publishing here actually doesn't necessarily mean to print. In fact, you're about to see a bill on the House floor on Monday that uses the word publish, but actually means put on the internet. Okay. So that's the first thing. But then the second thing is, again, now, unless the department, as part of its model policy, requires that it be put in the student code of conduct, which then does need to be distributed. That's
okay.
But that's not a specifically defined term, and it's at the end of the day part of a model policy. And yes, publishing could just mean placing on the internet.
Great. And my final concern is lines 78 and 79. Where a person reporting in good faith shall be immune from any civil liability. I'm thinking of a student who is falsely accused for whatever reason of bullying. That goes on his permanent record, and that student then receives his nomination to a service academy. And then when they do, as a service academy is going through their vetting process, they now see that this fine, upstanding young man or woman who really wants to serve their country and defend our country overseas and fighting for freedom, as they're occupying other lands. I'm wondering, why should someone be? And now they would be prohibited because the service academy wouldn't accept someone who has been even accused of bullying falsely. And I'm just maybe we could tighten that language up through this write-up process. That if only if the person has been determined through that procedure that you have on the prior page that to actually have bullied, just to make sure that just someone being accused of bullying. You better be sure if you want to make sure you're not you're going to be immune from liability.
Well, how does an accusation wind up on a permanent record?
A lot does. As a teacher.
Excuse me. The dialogue is between the members at this point. Thank you.
I just want to make sure that someone who really wants to serve their country, occupying other lands for our freedom, that they might that they wouldn't be precluded because of a false accusation of bullying. I want to.
It's the general false accusation. What are the ramifications, consequences of that later in any situation, whether it's a service academy application, could be a college application, could be a job application. To the extent that those things are even publicly disseminated, which candidly, or available, which candidly I don't know. But that's just something to the extent that it can be addressed, obviously there's at least one concern. Ms. Abrams.
Thank you, Mr. Chairman, and thank you, Mr. Jacobs. I first wanted to say publicly again, thank you for the work that you put into this and your willingness to work with the subcommittee to remedy this bill and to improve it. And I would ask that, just for anyone who's not able to be here at the next hearing, would you say that it's accurate to say that the purpose of this bill is to, number one, establish the obligation of school systems, teachers, and professionals to notice and to identify the activity of bullying, two, to provide guidance for those obligated persons to act to prevent or to intercede in acts of bullying, and third, to provide notice to parents and to custodians and guardians of their remedies. That this is not a criminal bill, it's not intended to criminalize activity, but it is nor is it intended to solve the human condition, but it is designed to create a standard of policies that permit parents to take advantage of the school system, but also obligate the school system and those employed by it to better protect our children.
I believe all of that would be a correct statement.
Thank you.
Ms. Abdul Salam.
Thank you, Mr. Chair. I want to just say that the chairman asked earlier what the report of the subcommittee was, and one of the things that I want to point out is that during the subcommittee, I think we worked on a lot of the concerns that we're talking about now, and you've done a good job. I appreciate your work with Representative Hughley, incorporating some of the issues in her bill. And one of the things that I want to point out to kind of make this real for those that weren't here for the subcommittee, a real reason that I appreciate this bill is that sometimes schools, administrators, principals, they don't react and they don't respond. I talk about the young man at one of my schools who our current district attorney actually had before her and when she was juvenile judge. This young man was bullied and beat up for months and months. He was being raised by his grandmother, who was elderly and disabled. He kept complaining to the teachers, to the principal, and nobody did anything. One day he got sick and tired. He stabbed a little boy with a pencil in the eye, as horrendous as it is. But nobody ever responded to his outcries of being bullied. And so if it does nothing else, it will give the schools and the administrators a guideline to obligation for at least dealing with it. And I think that that is very important. It is a real situation, and sometimes people don't take it seriously, or they just let it keep going, and we need something in place like this. So I appreciate that, and I wish that we were able to vote today. Thank you.
Chairman Ramsey.
Can you buzz me back in?
You 7?
Yeah.
Let's try 6.
Thanks. Is it not true that school systems already under current law are required to have a policy with respect to bullying?
That's correct.
And is it also not true that we give them absolutely no guidance what bullying means, correct?
That's correct.
And would you agree with the proposition that the kind of scenarios that Representative Byrd has come up with, and Representative Franklin, the 4 eyes, there's a better chance of a student being arbitrarily and capriciously punished for that? Because right now we're giving them absolutely no guidance under current law than if we provide them this definition that uses words like substantial, visible bodily harm, severe, persistent, pervasive. We're actually giving those students greater protection than exists under current law, because there's zero protection under current law. We say you have to identify if bullying's occurred, but we don't say what it is. Would you agree with that proposition?
I would agree with that, and furthermore, I've had a small handful of members come up to me and repeatedly ask, well, this is unclear, point to provisions in the definition, say, this is unclear, this is unclear, this is unclear. I beg to differ. I think the definition we have here is a lot clearer than the standards that exist already.
Well, there is no. Today, we just say school officials identify what bullying is.
That's right.
And then if you do, under current law, you already are required, if you find bullying, to send a student to an alternative school after three instances where you've identified bullying. You're already allowed under current law, even though we're putting it right here where they can find it in the bullying set. Already under current law, they're allowed to move a student to another classroom or move a student to another school, correct?
That's right.
So, I mean, I think we're actually providing students, in terms of a student being unfairly accused for some kind of absurd scenario like calling somebody Four Eyes. I think this actually protects that student from that kind of arbitrary and capricious allegation occurring because of what we're doing here.
I don't think that rises to the level of the definition we have here.
Yeah.
I really don't.
So, well, I was originally, when I pushed this button an hour ago, was going to offer a motion, but that's not going to happen today. But can I ask you just can I ask you one question? This is just kind of a technical question. Right now, current law says requires that a student be sent to alternative school after three times they've been identified as bullying. Correct?
That's correct.
And does the inherent authority exists, and we're kind of restating it here, where they're authorized to be assigned to another school outside their student attendance area? Is that a non-alternative school outside a student's attendance area, or could that?
It would be a it would be another school outside another school of the same type. But it couldn't be an alternative school. Is that what you're suggesting? Yeah, well, first of all, I think we also have to be clear that some school districts don't have alternative schools at all, okay? It's only in larger districts that you actually have alternative schools. But an alternative school is a specific creature in the education world. And what we are talking about in the something less than 3 strikes scenario, which is the language that really restates what is currently allowed, is a transfer to another school, another middle school, another elementary school, another high school, for the purpose of separating the 2 students, if that's appropriate, and only after an administrative hearing, for that matter.
Okay, thank you.
Chairman Cooper.
Thank you, Mr. Chairman. I'd like to thank you, Representative Jacobs, for bringing the bill. And I think the very discussion that we've had in this committee points up the reason, the need for this bill. I mean, we grew up, most of us have some age on us in this committee, and we grew up in another era. And there has been a societal shift. And that shift has been one toward a meaner, less respectful society. And yet I think what we found in some of the schools and the principals and the older teachers is they tend to look at real acts of bullying just as normal childhood behavior. And so I really think that this is a very much needed bill. We need to look at it through different eyes. And I appreciate you bringing it and all the work you've done on it. And I'll look forward to voting for the bill and getting to that stage.
Thank you.
I see no more member lights. Actually, I see Chairman Cooper, do you have something else? It looks like you pressed your button. Okay. So what I'm going to do, just so that the committee members and the folks in the audience will understand, so that we can at least begin to hear from witnesses, I do plan to hear from a couple of you in the audience. We clearly will not get through everybody. I plan to adjourn no later than 5 o'clock. If we lose members before then, if we get down to such a small number, then we may cut off much earlier than that. But we will certainly go no later than 5, and we may cut off a little bit earlier than that. Okay? We've got, it won't be a vote today, so we don't have to worry about a quorum. But again, I think that if we're going to ask members of the public to come comment, we need to have enough members here to be respectful of the fact that you've come down and taken your time. So, and is there anybody here who has, that's a very good point, Chairman Cooper, thank you. Is there anybody here who has traveled from outside of Atlanta to be here who wishes to be heard on this bill? All right. Where are they on my list? What is your name? All right, will you come forward, please, and when you get up to the mic, if you'll just tell me your name, tell the committee your name and who you're representing, or if you're representing just yourself, that's fine.
Good afternoon. My name is Miss Deborah Cobb. I was here last Thursday. You go ahead and sit. Okay.
Thanks. Go ahead and sit right there, and we can pick you up on the mic.
I just really, I'm for this bill being that I have a grandson, and I said it last Thursday, and I must talk about it again today, that was bullied, and we were going to court on February the 10th. I was trying to prepare my grandson for this court date, and my grandson had a relapse on the 2nd. And right now, as we're sitting in this room, my grandson has been admitted back in a hospital again because of an incident that happened a month ago at his school where he was socked in the eye. His eye was closed shut. So he had a relapse because he can't deal with, I guess, what's going on. And what happened, after he got out of school that day, I went to a awards meeting that day. He got 3 awards. My grandson is an honor roll student, and he got 3 awards that day, came home, got upset, got to talking about the incident that happened to him, and just took off out the house, ran up the street, and tried to commit suicide again. So now he's back in the hospital, but these are the certificates he got the same day he tried to take his life, and he's back in the hospital again. And that's why I'm so for this bill, and I just wish it would go all right so it would pass, because I'll go to the hospital to see him tomorrow, but he's had a relapse.
Well, thank you, ma'am. And on behalf of the committee, I know that I can express our sympathies for the misfortunes of your grandson. There is a question from a member, if you're willing to take some questions.
Okay.
Is that you, Ms. Roberta Abdul Salam?
Just one quick question. Thank you for being here. What was your grandson's incident? Was it at school, during school? And what was the response of the school?
No one called me. I was never notified. I didn't even know my grandson had gotten hurt until he came home and I noticed his eye. I immediately called the school and questioned it.
What's her name? We've got one more who came from outside of Atlanta. Let me ask members of the committee at this point. I live in Atlanta, and I'm happy to stay here until 5. But again, I know that other representatives don't live in Atlanta, so I'd like to take more. But I want to ask the pleasure of the committee. These are our 2 witnesses from outside. Are you willing and able to stay around a little bit longer to hear from other witnesses, or do we need to call it a day after this? All right. Well, let's do it. What time is it now? It's go to 4 o'clock. Does that work for the members of the committee? Okay.
Did Representative Jacobs leave?
I think he just stepped out because he was coughing. He didn't want to distract the witnesses. He's about to come back in with water, I would guess.
Okay. Anyway, I wanted to quote Representative Jacobs.
I know we're all familiar with you, but if you would just introduce yourself, just so the folks at home watching this will know who you are.
I'm just Jenny. I'm a snot, and I enjoy exercising freedom of speech and believe firmly in constitutionally restrained government. I'd like to quote Representative Jacobs. My bill is one that inherently trusts the local school system. We are only requiring that they require a policy. And he trusts them so much that if they fail to comply with this requirement, they'll lose their state funding, according to the last 2 lines of the bill. And it says that shall be utilized as a resource. He made sure that we understood that it's a resource, not a mandate. This is sounding very mandating. We have legislation based on an isolated incident, so we create a huge net to catch a needle. No needle gets caught, and everything else does. As already stated, you can't legislate morality into a godless evolutionary government indoctrination program that is top-heavy with bureaucracy in pushing forward an incredibly boring curriculum, thank you, No Child Left Behind, which has ensured that every child's left behind, and fed highly toxic, behavior-altering food 3 times a day, not including snacks and sodas. To Representative Franklin, a bully is perfect for the armed services, judging what happened to Abu Ghraib in New Jersey recently. So we also heard that this bill is to ask the teachers and faculty to notice bullying, act upon it, and provide notice. If our staff in school systems is so stupid not to automatically do that, I don't think we can possibly legislate that ability into them. The part of the bill on line 5 to direct the Department of Education to develop a model policy. The Department of Education is spending $32,000 per kid. We're 47th in the nation with a 30% dropout rate. I'm just a little skeptical skeptical concerning their ability to provide a model for anything. All the guidance from the current establishment has resulted in really expensive failure. I would recommend that we abolish the Department of Education. The part in line 21, other electronic technological devices, my first thought was Big Brother is watching you. The proper scope and authority of the school system was something that was said. I just find that amusing, especially since the school system has contacted me, threatening me with a social worker if I'm not careful about getting my homeschooling attendance reports in on timely fashion. Line 30 has the effect of substantially interfering with a student's education. If we have a bully, why don't we get rid of mandatory attendance law? Kids who don't want to be there shouldn't be there. The school system isn't for the purpose of babysitting somebody's obnoxious child that they are not doing a good job of raising. The whole intimidating educational environment, I would say get rid of mandatory attendance law again. A policy that prohibits, a singular policy, the Unimine alert is what came to my mind, more top-heavy jurisdiction. A single policy, no local control. Upon a finding on line 39, there's no definition for how that finding is found. Who has committed one or more offenses on 43? So after one offense, you can get the boot. This was kind of funny. Line 46, for the purpose of separating the student from his or her victim, as if that's going to stop the bullying. I just think somebody who thinks that solves the problem is crazy. I have 6 children. I run a student youth program in one church.
Let me just caution you. I don't mind your giving your opinion about the bill, but when it comes to calling the author, referring to the author of the bill implicitly as crazy, I just ask you to keep your remarks a little less personal.
I don't think Mike's crazy. I like
well,
Representative Jacobs.
That's
I was talking about.
That remark came across. So
I'm sorry.
I just want to caution you to do that. Thank you.
In terms of, maybe I can help this way. We were dealing with a situation in my student enrichment program that I was running at a church that I'm not currently. Currently, I'm at a church in West End, but in Marietta. And there was a kid who's a real bully. He was a constant problem. And at one point, he punched my daughter. And so I came in the room, and I went to my son, and I said, did you defend your sister when he punched her? And he said, no, I did not, because he's a lot bigger than me, and I'll get hurt. And I said, the next time your sister gets punched by anyone, if you don't come home with a bloody nose and 2 black eyes in defending her, you will be in trouble with me. So I took him in the backyard and showed him how to fight. And I said, I showed him how to do it. I said, you only use this if you're defending your sister. You always defend your sister. So a month later, that same kid punched my daughter. Jonathan took care of it. It never happened again. I think there's a sense in which we have mandated and controlled and policied our populace to death. So in line 58, a statement prohibiting bullying, we're trying to legislate morality into children that need parental involvement, parental discipline, and some of these kids just need to learn a lesson. The line 62 through 63, a requirement that each school have a procedure for the school administration to promptly investigate in a timely manner and determine whether bullying has occurred. This looks like a lot more paperwork. Line 73, a statement prohibiting retaliation following a report of bullying. That's interesting, kind of preemptive law. And then this part where we talked about the Department of Education shall develop and post on its website a list of entities and their contact information, et cetera, et cetera, et cetera. When I was reading through this line, it seems like the Department of Education wants a lot more authority over the local school systems, but as Representative Jacobs was saying, they don't want any of the responsibility in terms of being held responsible when their programs and systems don't work. I think bureaucracy is not the way to solve this problem. Some of the things that I would think that would solve the problem, hurting masses of children in decentralized schools maximize everyone's negative behavior. We have so many children in single locations. They're just rubbing shoulders with each other and bringing to bear all their negatives on one another. Small local schools that are the responsibility of local taxpayers and parents will result ultimately in less bullying and more learning. Radically altering the kind of food in the cafeterias. It's really appalling the kind of processed food we are feeding these children. I have investigated numerous studies on the results of feeding genetically modified food, food that's high in high fructose corn syrup and coloring additives and their modifying behavior effect on children in schools where they have radically altered the diet of the children in the cafeterias, installing kitchens where food is actually fresh food from local farms is prepared, has had a tremendous impact on the aggressive behavior of the children, making them docile and also taking in their information a lot better. The way our school systems are built now, the kitchens aren't even real kitchens. They're just there to heat up processed food. Also, amending the Georgia Code such that mandatory attendance is removed. Some teens need to get in the workforce or an apprenticeship program. One of the things in West End that we have is that when students get in trouble at their school, they come work in the garden because we've got a sustainable agriculture project behind our church. And a tired bully is a good bully. Have parents exchange contact information and hold each other responsible for their unruly children. Oh, hi, Mike. Are you still going to consider my bill I gave you earlier? I would buy you a beer, but that falls under bribery under the Georgia Code, so I can't actually spend any money influencing you. Okay, good. So this civil liability shall be, the person who reports the incident shall be immune from civil liability for any damages caused by such reporting. No personal responsibility in reporting. Anonymous reporting leads to corruption. I just find this appalling. It's like with DFACS. Anybody can call you and report you anonymously to DFACS. I just find that appalling. Parents should hold each other responsible for the people they're bringing into this world. I'm certainly responsible for what happens with my kids. And fortunately, if we had smaller schools in a local community, everybody lets everybody else's kid have it. I love my church in West End because my kids have like 50 parents. And everybody there will go, you are out of line, cut it out, don't be acting like that. But when we have these huge conglomerations of schools with, up to over 1,000 kids, it just
I'm sorry to interrupt you. I don't want to cut you off, except that when we start to get back, we're just getting back into the same things.
Right,
if you can just make new points, that would just help us because we're running short on time. And there is at least one member that wants to ask you a question.
Oh. Okay, so in terms of amending this bill, I would amend the Georgia Code to remove the compulsory attendance requirements. I would abolish the Department of Education, and I would also give local control of the tax money that's accrued so that the locals are responsible for the kind of education they put forward. And I would also add to it removing all genetically modified foods from the cafeterias and all processed foods from the cafeterias. Thank you for your time. Are there any questions?
Chairman Cooper. That's it. Thank you for your time. Oh, okay, a statement. Okay. Thank you, Jenny.
I'm really tired. That's not a statement for you. It has nothing to do with you. But I'm tired.
Can you pull down your mic?
Okay. I guess it's very easy for people who've grown up in middle-class households, maybe have done and had very little problems in their life, to sit and testify, or for us to say it's always the parents' responsibility for improving these children's lives. There are some parents in our society that are barely getting by, and their main concern on Maslow's hierarchy of needs is to put a roof over their children's heads and try to find enough food for them to eat. And some of the higher things on that hierarchy of what you do just get passed over because they can barely survive. And they're not at our schools because sometimes they can't get there because they don't have a car and they have to take 2 buses because of the system we have. It is not as easy as some people seem to think it is for them to have that input and for them to be punished because of that, or are always brought up that it's their responsibility or just because they're lacking. I'm just tired of hearing it. That's personal. I'm sorry, but I just needed to say it. Thank you very much.
Do any other members have any comments or questions? With that, I think we got the direction from Chairman Golick before he had to leave for another meeting. I appreciate everybody being here, the members and members of the audience. This, of course, will be continued, and we'll send out notices when the hearing is reconvened. Thank you, everybody, for your time. We're adjourned.
Was that all the testimony, or is that everyone who signed up to speak, or there's more people coming to speak?